hello and welcome back to my channel. Yes, as I've just updated, there has been a new document filed. Now, this was filed on June 25th. I think it was soon after, 2 days after the judge gave her decision. Now, it is my opinion and my view. And let me just preface to say that I am a law student and my own experiences with the Australian law courts. But it was done in a short amount of time. Usually, you get about 30 days before you have to file any new motions, etc., 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 because you need time to go through and study them. Sometimes you need to seek further advice. Sometimes you need to consult with other lawyers. And finally, you have to go through the legislation. You have to read the cases that the judges quoted. And you have to make sure that you know the law. So, but what's happened in this case is that 2 days later, this letter has been filed. Now, my understanding, motions, you normally fill out a motion document, and I've just pulled up the civil rules of procedure for Minnesota to see what the legislation says. Now, there is still no dates at this stage. I'm assuming that everything will be updated, but based on what I think the judge thought she left it open for motions to be filed, as we know. So we had this motion here, and then we've got this correspondence 2 days later. So we're going to look at the correspondence and see if we can make sense of it. Okay. So this is written on a letterhead. It says motion for reconsideration. So as far as I am concerned, if you are filing a motion, you need to follow the correct motion procedure. But I don't, as I said, I don't know. I can't comment on the specifics because, as I say, my knowledge is in Australia, but I know for a fact in Australia, you would have to submit documentation. And usually there is a form that you need to fill out that you can download off the website. It says, Dear Judge Willetts, pursuant to Minnesota General Rules Prac 11511, defendants respectfully request permission to file a motion to reconsider the court's June 23rd order denying in part their motion for summary judgment. Compelling circumstances warrant reconsideration based on the clear legal errors involving fundamental First Amendment protection that are dispositive of plaintiff's claims. So she's still talking about First Amendment right. So she's asking for permission to file a motion. Now, from my understanding, you don't need to get permission to file a motion. You would just generally file a motion. All that, in my opinion, is happening is court costs are going up. All right. And the other thing is, my other issue would be if I was so certain that I would win in court, I wouldn't be bothering. I would just let it all come out. This could be argued during the case. The court erred by treating protected opinion as actionable fact. The court commits a fundamental error by concluding that Ms. Paulson's commentary and use of hashtags could be found as defamatory. The First Amendment protection of free expression rests on the principle that under the First Amendment, there is no such thing as false idea, from Gertz versus Robert Welch. The order finds a jury question exists because Ms. Paulson, after stating her opinion, usually follows up those posts with hashtags referring to trafficking, human trafficking, sex trafficking, cults, and forced labor. And that's paragraph 34 from the order. This reasoning reveals a critical legal error. The court failed to conduct the required threshold analysis of whether hashtags themselves constitute protected opinion. The determination of whether a statement is protected opinion is a question of law for the court. See Jadwin versus Minneapolis Star and Tribune, which must be resolved before the issue of actual malice is even considered. Milkovich versus Lorraine Journal Co., holding that only statements that are provably false are actionable. Instead, the order conflates two distinct inquiries. Characterizing a group as a cult is a classic example of non-actionable opinion. In a fast-paced, abbreviated context of social media, hashtags like trafficking function as rhetorical shorthand to frame a topic of public concern, here alleged exploitation. Not as meticulously drafted criminal accusations. Such rhetorical hyperbole is not actionable. See Hunt versus University of Minnesota. The cult's failure to perform its gatekeeping duty on this question of law is compelling reason for reconsideration. Now, if you remember what the wording said, it said the jury could find. It didn't say it would find, but she said it was up to the jury to consider it. Now, without reading those cases, but this is what their arguments and their opinions. They're really going through the really trying to get those hashtags stated as opinion. But oh gosh, sorry. Okay, the misapplied the actual malice standard. The order incorrectly identifies that plaintiffs are public figures, but then misapplies the actual malice standard. Actually, I didn't think the court identified them as public figures. I think what they've said was it was never determined they were public. I'm going to have to pull up the judgment again. The plaintiff must prove that the defendant acted with knowledge of falsity or reckless disregard for truth. At summary judgment, the plaintiff must come forward with a clear and convincing evidence from which a jury could find actual malice. The order bases its finding of a tribal issue almost exclusively on the fact the plaintiffs disputed truth of Miss Paulson's statements in their depositions. Order 33, paragraph 33. So let's look at 33. Actually, let's go back a little bit now. Let's look at this now. I've got it open. So let's look at paragraph 34, which is which was her first argument. It says Ms. Paulson argues that the statements made by her regarding the plaintiffs are her opinion, do not qualify as defamation. However, the court carefully reviewed all of the plaintiff's videos and captions and does not find that they are all rooted in opinion. While Ms. Paulson occasionally claims her posts that the information provided in her posts are her opinion or are based on other people's allegations, she usually follows up these posts with hashtags referred to trafficking. When looking at the post as a whole, a reasonable jury could find that Ms. Paulson acted with actual malice. So here, the required threshold of whether hashtags themselves constitute protected opinion. But see, the judge had said she'd watched all the videos and that had to be taken in context. So now we get to this one. So this is the actual malice. So now they're talking about 33. Second, there are disputed factual issues regarding whether the statements were false or made by defendant with reckless disregard to truth or falsity. In the depositions, Mr. Shin, Ms. Derrick, and Mr. Derrick all dispute all of the statements made by Ms. Paulson in her various posts, including the meaning of 7M, the amount of control exerted by 7M and Mr. Shin over the Derrick and other dancers, and that Mr. Shin and 7M were engaging in forced labour and trafficking. The truth or falsity of these statements is a question for the jury. Now she's saying, hello, Ruth. She's saying that they must prove. Okay, the order bases its on almost exclusively on the fact that the plaintiff disputed the truth of Miss Paulson's statement in their depositions. This reduces the constitutional standard of common law credibility contest. A public figure cannot defeat summary judgment simply by saying that's not true. They must present affirmative evidence that the journalist subjectively. Well, here we go. Here's the other issue that we've got. We're back to this journalist thing. We don't actually have evidence that she's a journalist. They must present affirmative evidence that the journalist subjectively entertains serious doubts as to the truth. The order identifies no such evidence therefore improperly shifting the constitutional burden to the defendant journalist. But she's not a journalist. So they looks like they are putting their whole argument on the fact that she's a journalist. Again, I've not seen any documentation that actually has come out and said that she's a journalist. If you have that information, or you know where that's stated, could you please tell me? Because I would be very interested to know, please. Okay. The court failed to recognise that boycott advocacy is constitutionally protected, justification in tortious interference. The court fails to address that dispositive deposition. Oops. All right, I've just lost my virtual background. Sorry about that. Dispositive constitutional defence of plaintiff's tortious interference claim. The court found that Ms. Paulson encouraged people to boycott the plaintiff. Speech advocating for a consumer boycott on a matter of public concern is constitutionally protected and cannot form the basis of a tort claim. The order states that whether Ms. Paulson's alleged interference was justified is a factual issue to be decided by the jury. This is Order 51. Now, it's interesting though, they have not, if you remember, she, it said that she agreed, if we remember, there was a statement back here. So as to the public issue, if you remember, if the public disregard for the truth, so that's the standard. So it says, while the plaintiffs do not address whether they are public figures, they seem to concede that the actual malice standard applies to this case because they argue they have satisfied the actual malice standard in their pleadings and make no mention of common law malice. So the judge was saying whether they're public figures or not has not been addressed, but they've taken the highest stamp burden of proof. They've gone. There is something here that said that Miss Paulson agreed. She had said, yeah, it says, paragraph 7, Miss Paulson stated she'd encouraged people to boycott plaintiffs and their social media, and she'd shared information regarding companies who had cancelled their contracts with the plaintiffs. She admitted it in her depositions. But now she's saying, well, no. Now they're saying, no, that can't be right. The order states whether Ms. Paulson alleged interference for the jury. This is a clear error. While justification may be a fact question under the existence of a constitutional justification is a question of law for the court, establishing the court's duty of independent of constitutional fact. This is an oversight. This oversight is outcome determinative for counts 3 and 4 and constitutes a compelling circumstance for reconsideration. These errors fundamentally misapply controlling precedent. We respectfully request permission to file a motion for reconsideration. As I said, I've never ever seen somebody asking for permission to file a motion. Usually it would be an appeal. So you would normally fill out a motion to appeal for these matters, and then it goes to a judge that's got nothing to do with the case to make that determination. But essentially what they're saying is, from my interpretation, is that they don't want a jury to decide these matters. They want a judge to decide these certain matters. Now, when you have a jury, I mean, it's a bit of a hit and miss, really. So So it can be a bit of a hit and miss in it, you know. Are you going to be able to sway the jury and get them on side, or are you going to be able to you know, or do you think you're going to have better luck with the judge? So what's here is you've got instructions, general civil motion and affidavit, notice of motion and motion, affidavit in support of motion. So this is what they have to do when you have to file a motion, and a motion costs money to file. So this is what it would be. And, you know, you just fill this in and you write in what you want for the court to as order to relook at reconsideration of such and such. Lay it all out, and then you do that. So that is how things, I mean, as I said, my experience, and I am a law student, and I apologize for the garbage at the back. I'm a law student, so, and I'm based in Australia, so I don't have the knowledge of what goes on elsewhere. But you know, you would generally file motions, and so yeah, as I said, I'm a bit baffled as to why they have done that. But anyway, I'm just gonna blur out my background. I'm just gonna blur it out so you don't have to look at it. See if this works. That hasn't worked. Yeah, I'm just going to turn this off for a bit. So, yeah, so that's where we are. So that's everything that we've got. And they would put in an affidavit to support it. But I find it really bizarre that they would want to do that. It makes no sense to me whatsoever that you would write a letter to say, hey, we want this to be, we want permission to file a motion. The judge said, let me go back to here. Let's go back to the very last bit. She even gave instructions. Let me just show you this. Any discovery disputes shall be brought by separate motion. The court will contact parties for further dates of hearing in this matter. So, you know, and remember that they're saying that it could be reasonable. We're not looking at an absolute standard. We're not looking at beyond reasonable doubt in a civil matter. We're looking at the balance of probability. On the balance of probability was every single statement that Katie Joyce said, opinion. And the judge has said a jury may find this defamatory for these reasons. And so Katie Joyce going, well, no, you're wrong because, you know, this, because of this. So, which, and I'm going to tell you, it's her right to do that. She can do that. She has, there is no problem in her doing that. I guess the thing is, if she files a motion, it's going to cost money. So these are like, it's probably going to cost $75 to file the motion, and it's just going to add to the fees. Where they've sent a letter, and don't forget that her lawyers had to take time to write it. The other side's going to have to take time to read it and act on it. So if, for example, she loses and she has to pay court costs or legal costs, all of that's going to be added to it. So, yeah. So I'm interested to see what you think. And yeah, so I'm interested to see what you think. So replay crew, make sure you say hi and give me your opinion. I was just looking at changing the title, and I decided to use AI. I thought I'd see what AI would give me. And I'm just so Katie Joy's lawyers right letter to court, and then the AI's come up with Katie Joy's lawyers are out of control, exposing the depths of Katie Joy's legal despair, and Katie Joy's lawyers are hilarious. That might be a good title. There we go. We've got a complete joke or a comedy act. As I said, in everything that I have seen in relation to court filings, I've never seen a lawyer ask permission to file a document. They just do it. So, but I'm open if somebody would like to tell me where it's happened or that it's happened. I'd be more than happy to hear that, and I'm happy to be proven wrong. But I just want to also let you know that I'm a law student. This is my opinion on what I'm learning, and being an Australian, I don't really know how everything goes, but reading the documentation and that's my understanding how it would be conducted. As I said, I'm happy to be proven wrong, so you can let me know about all of that. Anyway, this is just short, sharp. I want to thank you for joining with me, and as we get more stuff, I will definitely let you know about it. But yeah, thank you for your support. Make sure you hit like and subscribe for me, and then that way we can keep everything going. But other than that, I will catch you all next time, and bye for now.